Hello, welcome back. Welcome back to Empowered Esquire TV. And this evening, we have a guest with us. We have Mr. Zion Lexx. Would you like to say hello to the people?
First and foremost, giving all praise to the Creator, thanking you for your platform, Felicia Pearson. It's been amazing to watch you. It's been amazing to sit behind the scenes as your commentary has been unfolding, and I consider this an honor to be on your show.
Thank you so much for your kind words, and you are welcome here. I want to say hello to everyone who is watching. If you're in the building and you want to shout out, just drop a quick hello in the chat. And if for some reason you've stumbled upon this live, but you're not quite sure why we're here, allow me. This is the saga of the state of Florida v. Michael Nowak, also known as Brother Polight, Part 2. So in the part one of this video, a lot of you had so many questions about the law, so many questions about bail, about prosecution, about arrest. And I thought to myself, there are a lot of outstanding questions, and I try to answer them in the comment section, but it just doesn't do. It's not as well as an actual explanation, right? So I realized that with everything that has occurred, we have to do a part 2. So Mr. Lexx agreed to be here with me. It's been amazing that he's going to be here because he's going to be able to share some of his observations as well as ask me some legal questions in regards to his observations and the situation at hand, right? So we have a really, really amazing guest in that regard. Now I'm going to hop into the chat and say hello to everyone. Hello, Health Light. Hi, Unforgettable. Hi, Fab 540. Hi, Nappy Yankee. Hi, Man King. Hello, Sheba. Hello, Flawless Beauty. Hello, Triple C TV. And Nappy Yankee says, share and subscribe, and I approve that message. If you've entered this stream, please hit the like button and share this video. So here's the order of business. First, I'm going to clear up some misconceptions that I've seen running rampant. And then Zion Lexx is going to kind of dig in with some of his questions, and then we'll open up the floor for your questions. So if you know that you have a particular question you'd like to ask, I would say make sure you stick around until towards the end of the stream when we open up the floor for questions, all right? So before I dive into bail, which is the first misconception I want to clear up, Zion Lexx, do you have anything you'd like to say?
I'd first like to just formally introduce myself to your following, your subscribers. So my name is Zion Lexx. I'm a published author 5 times over. I've written books that are available on Amazon as well as Barnes & Noble. I'm an outspoken speaker. I do a lot of public speaking. I'm also a museum tour guide here in New York City for the Metropolitan Museum of Art with well over 35 tours under my belt, with a special love, expertise, and interest in biblical studies, African studies with a focus on ancient Egypt and Ethiopia, as well as the language of ancient Kemet or ancient Egypt, as well as the language of the Bible, which is biblical Hebrew.
So as you have heard, definitely an intelligent guest we have today, right? Alrighty, so let's dive into, I prepared a document for you. If you missed the charges that Michael Nowak is facing, what those charges mean, what potential time of imprisonment he could be sentenced to, go back to part 1. You will see me log into that same document, but I've just tacked on bail into that same doc, and we are not re-reviewing that today. All righty. All right, so here we go. Let's go into my doc. So let's talk about bail. Now, I am hoping that this is large enough for everyone to see. Let me go ahead and make sure I can see the chat because I'm going to ask everyone who is here to put a Y in the chat for me if the wording is large enough and you can see it and read it. And in the meantime, I'll take a sip of water. So Y in the chat if you can see the wording well. All righty, I see the Y's coming in. Good. So let's talk about bail, everyone. Oh, goodness, I have to take a deep breath here. There have been some conversations about why Michael Nowak was granted bail. There have been people who have been insinuating that he was granted bail because he is innocent and that somehow bail is some sort of indicator of innocence. Now, I am not proclaiming to know the outcome of this case, right? I'm not proclaiming to know whether or not Michael Nowak is actually innocent or guilty. But what I am telling you about the criminal justice system is that bail has nothing to do with innocence or guilt. Now, I am aware that Tasha K has alleged that there was some mix-up with the documentation, and that is what led to Michael Nowak getting bail. Is it possible that there was a mix-up with the documentation? Yes. However, aside from that, right, separate and apart from that, bail has nothing to do with innocence or guilt. Let's dive into what bail is and what the factors are that a judge considers when he or she decides if someone should be granted bail. Okay, here we go. Bail. Bail is a monetary amount set by the court to secure a pretrial release. Pause. So it's an amount of money that a judge decides will guarantee that a defendant will come back to court pre-trial. Okay. The amount of bail is based upon the weighing of numerous factors. So it's a balancing of a list of different things. Here's the list. Past convictions and other past conduct. So that's the first thing. Failure to appear in court in the past. That's the second thing. Ties to the community, including family. So does this defendant have family members that he cares about that he would not want to flee and leave? Residence. Does this defendant have some sort of home with said family? And employment. Does this defendant have some means of garnering income that were he to flee, he would not have access to that? The nature of the crime the defendant is accused of. So one of the factors is for the judge to consider the type of crime that the defendant is being accused of. Whether the defendant's release poses a danger to the community. So the judge does also consider whether or not releasing this person could harm someone. Whether the defendant poses a flight risk. So whether or not the defendant could, whether or not the defendant has the means to escape in some way. And then financial resources, which financial resources and flight risk go hand in hand, right? Because if a defendant has a large amount of financial resources, then it's more likely that he or she could flee. So let's review these factors one more time. You're looking at a culmination of a bunch of different things that a judge considers when deciding bail. It is not just one thing. And none of these factors on their own is the deciding factor, because why? It is a weighing of all of the factors. So the type of crime is only one factor in this entire list, right? Posing a danger is only one factor in this entire list. So let's say, for example, hypothetically, of course, Michael Nowak does not have past convictions. Let's say, for example, hypothetically, of course, Michael Nowak has never failed to appear in court in the past. You get where I'm going with this? If the judge reviewed all of these factors and decided that none of these factors are really met, besides the fact that this is a heinous accusation, then the judge may have decided, you know what? I actually think bail is appropriate here. We get that? Don't worry, I will take questions. But we have to clear that up, people. We have to understand what bail is. It is essential to understanding the criminal process, okay? It's not innocence or guilt. That is not what bail is, because remember, you're considered innocent until proven guilty. Remember that. So bail is not innocence or guilt, okay? Now, someone in the comments said to me, bail, bond, what is that? Now I will answer the question of what is the difference between bail and bond. So bail is the monetary amount, right? Bond is a method used by indigent defendants to secure the monetary capital required for bail. So let's say hypothetically, Michael Nowak's bail was an amount that he did not monetarily have. He could go to a bail bondsman, right? Hence the term. And he could say, this is my bail. Can you secure that amount? And he has a transaction with the bail bondsman who then provides the amount. So that is the difference between bail and bond. All righty. I'm going to stop sharing. Hop back in the chat, say some more hellos. Hello, Sexy Star. Hello, Max V World Media. Hi, Major Moves. Let's see. I think there are a few people I missed. Hello, let me see your transcript. I think I've got everyone else. Oh, Nondescript, L. Smith, Calvin Brumont, Hannah Ajayi. If I butcher your name, please forgive me. Karen Johnson, and Muhammad Brett Edwards. I think I got everyone in the chat. Hello to you. You could be anywhere, but you are here with me and our esteemed guest for the evening, Mr. Zion Lexx. And we just talked about what bail is and how it is that someone is granted bail, because for some reason, people are saying that bail is innocence or guilt, and it is not. So to our guest, Mr. Lexx, is there anything that you would like to cover about bail? Any questions you have about bail before we move on?
Sorry, I was speaking on mute. I definitely have a question, but I first want to preface it with this statement. I want to please ask your audience to excuse my temperament. I'm overcoming COVID. I had COVID since Tuesday. I'm in the recovery end, so you might hear me quickly hit the mute button so I can cough. So please bear with me. All right, having said that, here's my question. So as you noted and as you stated, when Brother Polight received bail, as it were, everyone in the conscious community pretty much suggested that this meant that either A, the crime in question wasn't a serious allegation, or B, that no one can really put their finger on the pulse of what's actually going on with this case. Having said that, here's the question that I want to ask you. You quantify the difference between bail and bond. Now I want to ask you this. Would a person like Brother Polight, who fancies himself to have so many resources, mainly financial resources, what happens in the case where Brother Polight bails out, as he has, but maybe at some later date, Brother Polight is actually sentenced? All right. My question to you is, we know after a criminal case is over, right, a litigant can pursue a civil case, right? Could Brother Polight claim that he doesn't have money after producing large amounts of bail? After, if he was to be pursued by a litigant in a civil case, could he actually claim to not have money? I say that because there are a lot of sources that I know that are close to him. I just want to let you know that, who have been, made it very clear that his money is tied up among his wives and many other mistresses. So as if anyone was to pursue him legally in terms of a monetary stipend, that they really wouldn't get it. My question to you is, would the bail serve as proof that he has the means to pay if he is pursued in a civil case?
Well, that question depends on what the bail ultimately ends up being, i.e., if the bail conditions change. Because to our knowledge, based upon what we've seen, the bail is $1,000. So that, of course, would not be useful to any civil litigant. But let's say the bail conditions change and the amount goes up to something significantly higher. Yes, it is possible that a civil litigant could say, well, Mr. Nowak is arguing that he doesn't have funds. And we see that when he faced criminal charges, he was able to find bail in this amount and that amount. Now, I will add this. Any person who is taking Michael Nowak to court in a civil case, if they are alleging at the outset that they know that he is not the person who has, the bank accounts and the this and the that, then what they should be looking to do then, hypothetically, is bring the people with the money into the case which means bring his wives into the case as co-defendants. I mean, if you're saying you know from the outset that he doesn't have the money and they do, that's what you would do. Now, for example, to bring us to a general pop culture case that some of you may or may not know about, there's a big time lawyer named Eric Girardi. He's currently facing a bunch of lawsuits from people who allege that he took their settlement money. Well, what he was doing allegedly is giving the money to his wife. So guess what those civil litigants did? They brought the wife in as a co-defendant. They were able to substantiate that he was giving the money to her, bring her in as a co-defendant, and now she is the person having to pay them back. So if in fact someone decides to sue Michael Nowak hypothetically, and they allege that he is not the person with the money, common sense would say, bring in the people who do have the money.
Okay. Second question on the bail. Is it common with a case like this to see such low bail?
You know, bail fluctuates from jurisdiction to jurisdiction, you know, it's not even really state-based in general, because for example, you could see, you know, bail in a certain case in the Bronx and then see totally different bail in Brooklyn. And I'm sure Florida is the same way. You know, different counties, different districts, bail tends to fluctuate. So you really cannot look at the amount of bail as any indicator. To add to the fact that sometimes judges will consider what the financial capacity of the defendant is. And we have to remember that appearance and finances, actual finances, are not the same. You know, let's have a real life combo. We're living in the age of flexing, right? So just because you see someone online and they look like they have all this money, it doesn't mean they do. And so it's very possible that perhaps people who you think have all this money, when they get arrested, they're letting the court know that they really don't. And then the court is saying, oh, well, since we know that you're indigent, allegedly, we'll give you a lower bail.
That's an excellent point. Thank you very much for elucidating that point. Absolutely.
No problem. Do you have any further questions before we dive into evidence-based prosecution?
No, I definitely want to follow your lead. So yes, let's go into that next.
No problem. All righty. So I see a question in the chat. Now, there are tons of questions in the chat. I'm not going to be able to answer all of them right now, so I'd ask you to hold them until the end, okay? There is one question that I'm going to answer, just randomly picking one, right? But the rest of them, let's hold them until the end. All right, so Triple C TV says, what if he has the money tucked away somewhere else? So I think what Triple C TV is asking is, what if a defendant tells the court, I don't have money, but in fact, they're hiding money somewhere else? That is actually something that a lot of defendants do. A lot of defendants, to receive lower bail and receive some sort of sympathy from the court, will pretend to be indigent when in fact they're hiding money elsewhere. And truthfully, there's no way to attack that unless you can prove they're hiding money. And there has been instances in the past in where prosecution has been able to prove, hey, he's not indigent. You know, we know for a fact that he just transferred all of these funds to his wife, and we can prove it. It's rare, but sometimes prosecutors can prove that the defendant is pretending to be indigent when they are not. And the court does take misrepresentations and or lies to the court very seriously. It is not a good idea. All right. All right, so hello to everyone that is just joining us. We are revisiting the case of the state of Florida v. Michael Nowak. A lot of you had so many questions that the comment section just wouldn't do. And there were so many misconceptions, so we're here to clear it up. If you are just tuning in, we just discussed bail. We are now going to discuss evidence-based prosecutions. I'm going to actually take a moment. You guys know I cannot stand the clacky clack of the keyboard, but it is what it is. So I'm putting in the chat here, evidence-based prosecution. So we all see how it's spelled and we all know what we're discussing. So what is an evidence-based prosecution? Well, here it is. Many, many years ago, many moons ago, our criminal justice system decided that certain victims are very vulnerable. And because of their vulnerability, they're not likely to cooperate with prosecution, i.e., they're not likely to testify. So the government decided, what can we do to still prosecute these defendants when we have these victims who will not testify? And they developed something which, mind you, it is called different things in different places, but it's usually called evidence-based prosecution. It is very often used in domestic violence cases, and it has started to become something being used in these type of assault cases. So here's what an evidence-based prosecution is. Hypothetically, the victim in this case allegedly decides that she does not want to testify. The prosecutor in this case can say, well, I still think that I have a good case against Michael Nowak, hypothetically. I have alleged DNA, I have alleged hotel surveillance, and I can use the original witness statement from my victim. The prosecutor would then take a step back and look at all of that evidence and say, I'm going to go forward without her. That is an evidence-based prosecution. When the prosecution goes forward with a case, even when the victim does not want to. So there's no victim testimony. It is just evidence being presented. Hence the name, evidence-based prosecution. It is difficult to do. I can tell you as an attorney and a former ADA, they're not easy cases to prosecute, but it can be done and it has been done. Okay. All righty. So greetings to everyone who's just joining us. I see a lot of people saying hello to our guest. And let me ask you now, Zion Lexx, any questions about evidence-based prosecution?
Yes, since we're speaking about evidence-based prosecution, I'd be remiss to not add that there's a growing number of people who are, I guess, confused or out of the loop as regards the evidence on a more clear or lucid level. For instance, the term DNA, it can refer to or it can infer a number of different things. DNA does not have to be one particular thing. So I just want you, if you can, to just clarify for us the fact that the docket mentions DNA. That is not necessarily proof that it is coming from Brother Polight's semen. DNA can come from many different things, your spit, your blood. So this leads to people saying, well, if his DNA is on the girl and he's dating the mom, maybe he's in close contact with the girl. Some people spit when they talk. There's nowhere in the paperwork that says it's semen. What do you say to that?
So there is the world of possibilities and there is the world of practicality. So is it possible that this DNA is something more common, such as, spit or sweat or something of that nature? Is that possible? Yes, that is possible, because as it has been said, we do not have an actual snippet of documentation which says some sort of, semen or sperm or something like that, right? So technically, it's possible. But from a practical perspective, it would be very challenging for any prosecutor to want to build that kind of case on bodily fluid that would have not been secreted in some sort of inappropriate conduct. So, for example, if it's a bodily fluid that, as Zion Lexx is saying, it could just come out of your mouth when you're speaking. Well, that's going to be a more difficult case for you to build, right? So just putting on your prosecutor hat for a moment and using your own sense, your own knowledge, you could say, it's not likely that a prosecutor would choose to prosecute that kind of case. They would want to have bodily fluid which confirms inappropriate contact, and that would be semen or sperm. That's the ideal.
Excellent point. Now, I have one question for you, another for you, and this question revolves around the parallelism or how in some states this term is made synonymous, rape and sexual battery, right? We know in the state of Florida, rape and sexual battery are synonymous. They're one and the same on Florida's legal books. But I'd like for you to just, clarify for us what the differences are, if any, between sexual battery and rape, and why, if at all, some states may use them interchangeably.
So some states may use the term interchangeably because very often they're both used to refer to inappropriate intimate contact, whether it be with lower portions of the body or upper portions of the body, right? So that's why sometimes it's used interchangeably. But usually when making the distinction, battery refers to inappropriate conduct, whether it involves, as I said, the lower portion of the body or the upper portion of the body. And we do know that allegedly in this case, most of the allegation and most of the observation that was made by the mother allegedly has to do with the girl's face, right? So that is why you hear references to battery as opposed to the R word, because the R word is usually something that involves your nether regions. That's the distinction there.
Thank you so very much for clarifying that, because I was looking into it and I was, just familiarizing myself with the term. And then it dawned on me that it would be a great moment to ask you that question. So thank you very much. You certainly answered it.
Absolutely. Absolutely. So I wanted to make sure we clarified, what is bail? What does that mean? Does it have anything to do with innocence or guilt? And could this case possibly progress with a victim, allegedly, who decides that maybe she does not want to go through with having to deal with that? And let me say this, if for some reason you are unaware, and let me tell you, if you're unaware of how these cases work, I actually think that that's a good thing, because it means that you've never had someone go through this. But these type of cases, in particular, cases in which, inappropriate intimate conduct is alleged, for the victims, it is especially harrowing. It's very, very difficult. It's very traumatizing. And very often victims walk away from these cases not because they're lying, not because what they're saying and alleging didn't happen, but because they just psychologically cannot handle having to go through this again. So hence the conversation about evidence-based prosecution, because I know a lot of you wondered what could happen if this young lady does decide, or girl, however you like to refer to her, right, does decide that she just cannot do this. She cannot go through with this. So we're going to open up the floor for questions from Zion Lexx. And after he asks all of his questions, then we will go into the chat and get some of your questions. So, Mr. Lexx? Yes.
So, I've already seen a lot of people ask questions as it pertains to Polight's past dealings in the community as it pertains to scamming. You said something in your initial video with reference to Brother Polight specifically that I found very valuable. You said something to the extent when we were talking about, excuse me for a moment, let me just jog it and get my words correctly so that they can come out clear. But as it pertains to establishing a pattern of behavior, that's what I'm going to ask you. So is it possible that Polight's prior history of scamming could be pulled into court, invited into court by the prosecution to establish a pattern of not necessarily sexual battery, but a pattern of, bad character in some way, in some sense?
Very, very interesting question. So the short answer, yes. But of course, I have to explain that. So here's the long answer. It is more likely that Michael Nowak's past regarding alleged scamming and all those things, it's more likely that that could be brought into this case if he decides to testify. And the reason why I say that is because witness credibility, if you're an OG, you know what I'm about to say, but if you're a newbie, welcome. Witness credibility is always relevant. And a part of witness credibility is the witness's character for either truthfulness or untruthfulness. So that means, is this witness the kind of person that would tell us the truth? Or is this witness the kind of person that has a track record of being a dishonest person? And when you talk about allegations of scamming, allegations of any type of fraudulent collection of money, allegations of fraudulent business practices, all of that could be considered showing that someone has a character for untruthfulness, showing that they're not a trustworthy person, which comes into play, like I said, if the person decides to be a witness. Now, if he decides not to testify, the prosecution may still try to go for it, because that's the thing about the legal world. It's adversarial. So like I always say, I'm going to make the argument. I'm going to go for it. And then the judge will tell me if I made it or not. So the prosecution may make the argument of trying to bring all of the alleged scamming in, even if he doesn't testify. But it's more likely that they will be successful if he does, because then the judge will say, well, I have to consider this because I have this man on my stand as a witness, and I have to evaluate if he's a credible witness or not. And if he's been lying and having shady business practices in his professional life, I have to consider that as to whether or not he is telling me the truth on the stand in this courtroom.
Excellent points. Excellent points. Thank you very much. I'm all the way satisfied with that answer.
Wonderful. Anything else?
Yes. Brother Polight, he debates for a living, as it were. So he's well versed and trained in defending himself. So Brother Polight taking the stand would actually tie into his ego, and many of us that know him personally would actually know that he more than likely would take the stand. However, my question pertains now to the young victim alleged in question. Does her taking the stand strengthen her case versus her not taking the stand weakening her case?
So whether or not her taking the stand would strengthen or weaken her case depends on her credibility. Because as we just discussed, witness credibility is always relevant. So if in fact, and we're about to have a conversation that I may say things that you may not, and not you, Zion Lexx, but viewers, right? That you as a viewer, you may not like, but I am telling you how the process works, okay? So if she is a girl who appears to be trustworthy, meaning she dresses a certain way, she presents herself a certain way, she speaks a certain way, she hasn't gotten into any trouble with the law, she tends to do well in school, right? These types of things. These are the kinds of things that the prosecution will look at and say, I have a solid witness. She dresses age appropriate. She speaks age appropriate. She, appears to be someone that would garner sympathy and garner you to think I can trust this girl. So the prosecutor is going to evaluate whether or not she would come off as a good witness, i.e., does she appear to be trustworthy? And then, of course, ultimately, she has to decide if she's comfortable testifying. If she is a strong witness and she testifies, there is nothing more sympathetic and more convincing than a child, a competent, trustworthy child witness, because juries understand, just like a judge understands, how much courage it takes to be on that stand. Imagine as an adult how nervous you would be to testify. And now imagine if you were a child testifying. So juries and judges, they see that, they recognize that. And so when they see a child on the stand, they think, wow, this took a tremendous amount of courage. So if you add to that she appears well and she comes across well, that could definitely make her case stronger.
Okay, let me ask you one more question. Would you agree that it's not in the best interest of the defense to badger her while on stand, to really, shake things up by putting, let's say, the pressure on her because of the delicacy of the case and the idea of the jury more than likely being sensitive to the young girl? Would you agree that the defense has to approach this in a very tactful manner, because the subject matter obviously is very delicate and the jury may not take a liking to that?
I would agree. And I'm sure that his defense team is aware of that. These cases always have to be approached in a very, very sensitive manner. And it has to be done in a way in which the defense attorneys are really talking about the evidence, and not attacking the victim. Because attacking a minor victim is a terrible idea. So I'm almost certain that that is not their defense tactic. It will probably be just to stick to the evidence doesn't show, the evidence is not solid, the DNA is shaky. It should probably be somewhere along those lines, and probably not trying to attack a minor, because that's a terrible idea.
Okay. Okay. Now, being that there is already a trail on YouTube of various videos where Polight is almost implicated or incriminated by people that he knows, inferring that Polight may have done this before with other people, how much consideration do you think a credible prosecutor will actually take that into consideration as useful info and work on it to the extent that there might be a YouTube video out there that might be extremely valuable in this case?
So here's what I will say to that. There are, to my knowledge, videos out there in which people affiliated with Michael Nowak allege that he has had inappropriate contact with minors in the past. This is not me saying that. This is not even Zion Lexx saying that.
That's right.
People that are affiliated with him have said that. Now, any prosecutor who wants, as I said before, a strong case is going to try to bring those allegations into this case. They have two ways they can do that. They can try to bring the actual video into court, which they have to overcome some hearsay issues, right? But perhaps they can find a hearsay exception. We don't have the time to get into all the hearsay exceptions today. There are so many of them. But know that there are many hearsay exceptions. So just because something is hearsay does not mean that it may never see the light of day in court, right? So they may try to bring in the actual video. Polight's defense attorney should say hearsay, objection to that evidence. And then the prosecution should provide some sort of argument that is either an exception or an explanation that would convince a judge to allow it in, right? That's one way. Right. The second way is they could get the actual person in the video. Hey, such and such, this is ADA or ASA from such and such Florida. I see you made a video regarding my defendant and his past conduct, and you're alleging that he's done in the past exactly what he did in this case. Would you like to speak to me, or should I subpoena you? You let me.
And how strong, just for the layman, myself included, how strong is the power of the subpoena out of state, for someone in this case?
Subpoena power is subpoena power. It is the same all over the country. Now, of course, it's more likely that you're facing higher penalties if you try to ignore a federally issued subpoena, but a subpoena is a subpoena, regardless.
Okay, so there aren't different levels of subpoena at all?
No, there's just different levels of consequences. It's just more likely that a federal entity could really go after you if you ignore them. That's what it is. Everyone has, as far as government entities are concerned, they all have the power to try to go after you in some way if you ignore their subpoena. You're just more likely to catch heat ignoring a federal subpoena than a state or a district subpoena.
What penalties, if any at all, are associated with failure to answer a subpoena?
It could be obstruction of justice. So if you're unfamiliar with that charge, obstruction of justice is when the government alleges that a certain person is preventing prosecution or preventing the development of a case because they either refuse to appear, or they refuse to give evidence, or they refuse to testify. So obstruction of justice is probably one of the main charges. And the judge could even find the person in contempt of court, because remember, the judge is also a part of this entire process and is signing off on and agreeing to these subpoenas that this person is allegedly just choosing to ignore.
Absolutely. Absolutely. Okay. Having mentioned these videos on YouTube, so, I initially reached out to let you know that I had actually participated in a video debate with Brother Polight 11 months ago, in September of 2020, at, I believe, what was his Beverly Hills penthouse. And during this debate, the topic was centered around rape. And although Brother Polight did not at any time in the video definitively say that rape is okay, you do see him, however, arguing in favor of the idea that rape is not okay in the Bible being wrong. So my question to you is, how likely, if at all, can a video like that be used without a definitive statement? Would the prosecution take the time to play the entire 30 minutes and have the entire courtroom sitting, listening, and discerning it? Or would we need the key parts, if any at all, where he makes a definitive statement? In this case, he doesn't. And so because he doesn't make a definitive statement, it really has no value. What do you say to that?
So before I answer the question, I want to give a big hello to Information Man Show. If you're unfamiliar with him, I can't believe that. He's awesome. You should check out his YouTube. He covers a range of topics and does so eloquently. And I also want to give a big shout out to K Business Podcast, another great channel you should check out. He covers a lot of good business topics and gives great entrepreneurship advice. And of course, hello to Let Me See Your Transcript. Check her out as well. She also has some awesome content. Alrighty, so now to answer the question at hand. So some of these videos, which I have been sent them and I've reviewed some of them, do not have definitive statements in them. That is true. However, it depends on the diligence of the prosecutor as to whether or not, because as I said, it's an adversarial system. So you can always make the argument and let the judge decide. So a very, very diligent prosecutor is going to pull all of these videos, any video in which Michael Nowak even says the R word. They're going to pull it and they're going to take it into court and say, Your Honor, we're arguing that it should be admitted. We're arguing that here are our hearsay exceptions. Maybe it's an admission on the defendant's part. Maybe it shows his mindset in regards to this type of assault. Maybe it shows past conduct, this, and that. They have tons of arguments they can make. But a diligent prosecutor will trot out every possible video, argue for all of them, hoping that they maybe get at least 2 or 3 of them admitted.
Okay.
Now, a prosecutor who's maybe not as diligent or maybe not as tech savvy, you never know, may decide, you know what, I don't need any of that. I'm going to stick to my case. I'm going to just argue my case and call it a day. But I will tell you that from what I have seen, Michael Nowak's presence online is a treasure trove for prosecutors. I cannot imagine a prosecutor who would not see his online presence and go, oh, like, oh my goodness, jackpot, right? I cannot imagine a prosecutor that would not go through his online presence and try to use that.
Makes sense. All right.